So let's do this. Let's get rolling. We've got a good chunk of people here, got some energy. So I'm going to now turn it over to my co-facilitator, Katie Wilson of the Transit Writers Union, to introduce herself and to present on Amazon's monopoly power.
Okay, hello everyone, good evening. I am very excited to be here tonight to dive into this exciting topic. I work with the Transit Writers Union, as you can see from my awesome hat, one of the many fun things we have in the Transit Writers Union. And I am going to now share my screen and walk us through just a little slideshow to kind of set the stage. So, okay, hopefully you can now see my screen. Cool, okay, let's do this thing. So let's talk a little bit about monopoly and our favorite local business. I am going to move us through this slideshow at a pretty good clip, but at the end, we will put a link to the slide deck in the chat so that you can look back at anything you missed or want to see more closely. So let's start with the question, what is a monopoly? There is kind of a narrow definition when a single seller totally controls the market for a particular good, but that's kind of an extreme case. However, it turns out that monopoly-type behavior and its negative consequences appear in a much broader range of situations. So here's a broader definition. A monopoly is a company that has so much power that it sets the terms of an interaction. Basically, customers, suppliers, workers, etc., just don't have a realistic and competitive alternative to doing business with that company on that company's terms. So the monopolist gets to write the rules. So let's talk about Amazon. We all know that Amazon is enormous and unbelievably wealthy. In fact, Amazon recently became Washington State's biggest employer. But is being really big enough to count as a monopoly? What do we actually mean when we say that Amazon has monopoly power? Amazon's monopoly power is most visible in its command of online commerce. If you are buying something online, chances are your search starts on Amazon.com. And that dominance ends up being self-reinforcing. So sellers have to list their products on Amazon because that's where the customers are. Customers go to Amazon because that's where all the products are. So that gives Amazon enormous power to write the rules, especially as its algorithms shape what customers see and what products get bought. There's a second dimension of Amazon's monopoly power, vertical integration. So Amazon is not just a marketplace or just a retailer. Over the last couple of decades, Amazon has become a major player in many, many industries. And this gives Amazon an enormous advantage against its rivals because it can leverage dominance in one sector to gain an advantage in others. Another less visible but increasingly important dimension of Amazon's monopoly power is its cloud computing division, Amazon Web Services. This is really Amazon's cash cow, a source of revenue that allows the company to sustain losses and take risks and outcompete its rivals in other lines of business. It's also increasingly the infrastructure of the internet. Amazon controls about a third of the cloud market, so very often the websites of Amazon's rivals run on Amazon's cloud services, creating potential conflicts of interest. We saw recently Amazon flexing this muscle just earlier this month when it booted the social media platform Parler off the internet. Now, probably most of us were very glad to see this happen, but the fact that Amazon was the entity that was making that choice really raises some big questions about free speech and democracy. What does it mean that it's up to a private company to make a choice like that? So those are a few dimensions of Amazon's growing monopoly power. But let's talk about some of the impacts. Let's talk about a few examples of how Amazon uses or potentially abuses its power to set the terms of an interaction. Small businesses. So there are a million things to say here. And when you get into kind of the antitrust kind of complaints against Amazon, small businesses always come up first. I'm just going to mention a couple of things. So this is a quote from a New York Times article. Amazon punishes the businesses if their items are available for even a penny less elsewhere. It pushes them to use the company's warehouses, and it compels them to buy ads on the site to make sure people see their products. All of that leaves the suppliers more dependent on Amazon and scrambling to deal with its whims. For many, Amazon eats into their profits, making it harder to develop new products. Some worry if they can even survive. And of course, Amazon has also used its vast troves of data to copy successful products of third-party sellers and sell them under Amazon's own brands. So how does Amazon's monopoly power impact workers? Again, just a couple of examples. When Amazon dominates the labor market, as a worker, you don't have a lot of choice but to accept the working conditions that Amazon offers, even if they suck. Amazon also has basically unlimited resources to put into union busting. And this here on the right is a quote from a recent study by a couple of Federal Reserve Board economists, which makes the case that concentration of market power in a handful of companies has contributed to stagnating wages and rising wealth inequality over the last few decades. Along similar lines, communities desperate for jobs feel like they have to accept Amazon's terms. We saw this play out on a grand scale in Amazon's highly publicized HQ2 search a few years ago, but it plays out at a smaller scale as well. So this is from an article about Amazon's expansion in the Chicago area. Amazon extracted subsidies from communities where it located warehouses and other operations. And this is the quote, "Records show the three largest incentive packages Amazon received, totaling $512 million, all came from predominantly Black suburbs. By contrast, the company built warehouses in at least 7 mostly white communities that reported offering no public incentives at all." So basically, the least advantaged communities get taken advantage of the most. Amazon's dominance in the digital realm also raises questions about privacy and human rights. Amazon has come under criticism for providing cloud services to US Immigration and Customs Enforcement, or ICE, and Amazon Ring has been partnering with police departments around the country on surveillance for free. And then it, of course, upsells the police departments to start using Amazon Web Services. Amazon collects reams of data about individuals and businesses that use its services. So all of this kind of adds up to a worry about Amazon's role in constructing a surveillance state. Should we be worried? Yes, we should. Finally, democracy. So economic power often translates into political power. We have quite a lot of experience with this in Seattle, where Amazon used its clout to kill a big business tax in 2018, and then tried really hard to buy our city council elections in 2019. Thanks to grassroots organizing, these particular attempts did not ultimately work out so well for the company. However, Amazon is getting more politically astute, and at the national level has started directing more and more resources into lobbying over the last few years. So Amazon's monopoly power is a problem, a growing problem, but what can be done about it? Broadly speaking, there are a couple of approaches which are not mutually exclusive. First of all, you can break up monopolies into smaller pieces, old-fashioned trust busting. And this is what ultimately happened to many of the big monopolies or trusts of the Gilded Age, including the Standard Oil empire of John D. Rockefeller. In Amazon's case, this could mean breaking off some of its different lines of business into separate companies. The other approach is to kind of accept that there's not going to be a lot of market competition in a particular industry or sector of the economy. Rather than trying to restore competition, the government can impose regulations so that dominant companies can't exploit their dominance unfairly or destructively. Or you can go even further and bring an industry into public ownership and control. Today, antitrust, which is the area of law and policy that's aimed at tackling the dangers of monopoly power, is making a comeback. So for decades, the US government and courts have favored a narrow interpretation of antitrust law. Basically, unless you can prove that a company is using its monopoly power to raise prices for consumers, they're not doing anything wrong. But now, over the past decade or so, with the rise of big tech, and growing awareness of the kinds of impacts that we just have been looking at, there's a new movement to revive and expand antitrust law to combat monopoly power in the 21st century. Last year, a number of groundbreaking antitrust actions were brought against big tech in the US and in the European Union. And Amazon has not yet faced an antitrust lawsuit from the US government, but could well be next. And that's where we're going to leave it. So, and I'll just end with a reminder that, of course, antitrust is just one tool to combat monopoly power. Many of us here are organizers or activists. Some of us have been involved in campaigns taking on Amazon and other corporate giants. Hopefully, tonight's discussion will help you to start thinking about how monopoly and antitrust relates to the issues that you care about and the things that you're working on. So now I'm going to hand it over to Elena, who will tell us what's next.
Speakers. First of all, I'm putting the bio in the chat. Jonathan Mark is, let me scroll back up here. Jonathan Mark is the Senior Assistant Attorney General at the Division Chief of the Antitrust Division at the Washington State Attorney General's Office. You can see a little bit more about his experience and what he brings to the table with us in the chat. And also I would love to welcome Lynn Trun, who is an Assistant Attorney General with the Antitrust Division of the Washington State Attorney General's Office also. And in addition to doing all of that, I've got to say it, she juggles a full-time second job as a full-time mother of 2 children. So welcome, Jonathan and Lynn, and we'll turn it over to you.
Great. Thanks very much, Elena. Can everyone hear me okay? Thumbs up. Great. So let me press some buttons here to share my presentation, and I hope technology, hopefully big tech tries to or is going to comply here. Okay. Just bear with me a moment. Okay, so can folks see that?
Yep, looks great.
Okay, perfect. All right. Well, so we're really excited to be here to talk a little bit about what we do and the antitrust laws, a subject that, of course, I'm biased, but I think is extremely interesting and fascinating. And you definitely do see it more in sort of the, in current events. So I think what we're going to try to do is we're happy to take questions during the presentation. So Lynn and I are going to tag team. If you have questions that you want to ask, I think we'll have folks send it to the chat. And Lynn is going to kind of monitor that while I'm presenting, and we'll kind of read the questions aloud. And we probably won't be able to get to all of them, so we'll just kind of, in the interest of time, and just kind of maybe filter some of them so that we can, kind of get through the presentation. But we also have some time reserved at the end for Q&A. So let me move us along here. I like to joke, we know what you're thinking. The antitrust laws sounds really boring. It's kind of this esoteric kind of niche area that you sort of hear a little bit about, but, it's not really something that, kind of affects my day-to-day all that much. But as I like to point out, the antitrust laws are actually cool enough to have been sort of the subject of at least 2 Hollywood movies, one creatively named Antitrust, and then the other one was The Informant with Matt Damon. So, The Informant is a great movie, maybe not Antitrust so much, but check them out if you have time. But there's also lots of other ways that the antitrust laws really affect our day-to-day in more ways than we may appreciate. And so I just kind of have a smattering of, different things here, computers, football helmets, monitors, memory chips in computers, prescription drugs, hospitals, all of these, the stock market, all of these in one way or another, have been affected by the antitrust laws, whether it's an antitrust lawsuit or, some type of resolution that caused, changes in some of these industries. So, the antitrust laws are pretty ubiquitous in that way. And, in ways that may not always be totally obvious. So, just a quick antitrust 101. And so first, what are the antitrust laws? So, I think of the antitrust laws as, the rules that protect the rules of the road on competition. So, as a general matter, the prevailing view is that, when there's aggressive competition among sellers, consumers get the benefits of that. And there can be lots of different ways that we see that: lower prices, better products and services, more choice, more innovative products. And I like to think of the antitrust laws as, the rules of this road. And so our job, Lynn and I, what we do is our division investigates and enforces federal and state antitrust laws. And we do that basically by conducting investigations. We have the ability to ask for confidential information, documents, to take depositions, and basically, gather lots of facts and determine if there's a violation of state or federal antitrust laws. And then if we think there is one and it can't be resolved, then we can file a lawsuit to try to remedy that violation. There's a lot of different sort of pockets of antitrust, which I'll talk about. But one of the things we do, in addition to looking at mergers, we bring cases to get money back for consumers. Over the last several years, we've recovered over $100 million for consumers and for state agencies who have been harmed by anti-competitive conduct. And I'll talk a little bit about that next. I put, maybe I should pause here. Lynn, if there's any questions, I'll slow it down a little bit if you want to jump in. So sorry if I jumped over you.
No questions, Jonathan. Okay,
so there's kind of three basic buckets that I sort of view the antitrust laws as sort of encompassing. So agreements that unreasonably restrain trade. What the heck does that mean? We're talking about things like price fixing and bid rigging, when competitors agree on things that, harm consumers, on terms of trade. That's kind of one bucket. Then there's monopolization, using market power to engage in competitively unreasonable conduct. And then the third bucket is mergers that anti-competitive mergers. And I have an example there of, Coke buying Pepsi, two large soda producers. And there may be anti-competitive effects with that. Those are kind of the three big buckets. We'll make this presentation available for folks if you want to take a closer look. But really, I just kind of have the language of the statute of the law here, both the federal and the state antitrust laws. And so, if you have heard about the antitrust laws in the past, you've probably heard about the Sherman Act. That's the federal antitrust law. And I have there on the slide kind of the bedrock federal antitrust law, Section 1 of the Sherman Act. And then our state law analog is the Consumer Protection Act. And so the antitrust, essentially the federal antitrust laws have a state law counterpart that is all found in the Consumer Protection Act. And you'll see the language there is pretty, it's pretty similar. And again, this law will prohibit things like price fixing and bid rigging. competitors deciding, hey, let's all charge the same price for these widgets, and then as a result, everyone overpays for them. So that's kind of the first bucket. Move along here. Oops, sorry about that. Monopolization. That's Section 2 of the Sherman Act. And so you can see the language there in the State Consumer Protection Act. One thing that I think is worth noting is that, it's somewhat counterintuitive, but it is actually not, under the US antitrust laws, it is not illegal to be a monopoly. What is illegal is acquiring monopoly power through competitively unreasonable conduct. And the rationale behind that is, we want to encourage folks to build a better mousetrap. And if you do, then you deserve to reap the rewards of that. If you engage in competitively unreasonable conduct, in your goal to build the best mousetrap, that's the problem. So the monopolization statutes, that language there is not intended to make monopolies illegal, but to regulate, to police the conduct on how you conduct that business. And then last but certainly not least, anti-competitive mergers. That's I have the language up here, and really the standard for that is whether a merger substantially lessens competition. And so that would mean that these laws reach mergers or acquisitions of companies that compete head to head, or sort of constrain another's conduct. I know that this business is kind of on the wings, and I need to be careful if I'm going to swoop in with this new product and price it really high. Maybe they'll come in and undercut me. So that's the general. Those are sort of the three main buckets of the antitrust laws that we work with.
Jonathan,
yes.
There are a few questions in chat that I want to make sure we are able to get to. The one was back to the example of Coke and Pepsi. Based on an example that was given, what's the reasoning behind Coke not being able to buy Pepsi, but they can buy, say, Sprite or Fanta? So essentially another soda company.
Yeah, so to answer that question, I think, I'd have to talk a little bit about how a merger is analyzed. And so the first two things that if you are going to, if we want to file a lawsuit to stop a merger, there's two basic things we have to analyze. We have to first analyze what the product market is, and what the geographic market is. So what does that mean? The product market is, in the case of Coke and Pepsi, maybe it is, carbonated soda beverages. On the other hand, maybe the product is, beverage, any sort of liquid beverage refreshment, right? So it wouldn't just be, like traditional Coke and Pepsi. It could be like orange juice or lemonade. And so you can see that's where a lot of the disputes will, arise, and where the lawyering will arise, because how you define the product is extremely important to how much competition there's going to be. And the way those products are defined is through investigation, expert analysis, working with economists to figure out how do we prove this to a court, and then the geographic market is where do they compete, and in the case of Coke and Pepsi, clearly they're all over the country. So I think really it would come down to if the price of a Coke can rose by $1, would people switch to switch to a Sprite. And if they do, then that means that, boy, Sprite's a substitute. It competes with Coke, and maybe that is part of the product market. So that's why these cases, that's why we investigate. We have to do a lot of investigation of these cases to answer those types of questions, because at the end of the day, a court has to agree with how we have defined the market, and whether or not it is going to be anti-competitive or not.
I'm seeing a lot more questions in the chat, which is very exciting, because it seems like you guys are getting into this topic, which is great. I apologize in advance that we probably can't field all the questions, so I'll try my best to go through them. Another question in chat was, can you give a Washington example of stopping a merger?
Let's see. So one of the things that frequently happens is when a deal comes to us, we investigate it, and there may be parts of the transaction that are okay. They are they're not anti-competitive. Maybe they're competitively neutral, or maybe they are even pro-competitive. But there are other parts of the transaction that are anti-competitive, right? We see that there could be some potential harms. So there are many cases where we can negotiate a resolution to let the deal go ahead, but they have to do certain things to fix those competition problems. They maybe have to sell off certain lines of business, or they have to there was a new product in development that they have to divest to another competitor to develop that. And so there's examples of that happening in pharmaceutical cases. In one of the earliest cases that I worked on involved a merger of school bus companies, and they all competed with one another for contracts with school districts. So they had to transfer some of those to a competitor. There's certainly we brought lawsuits against healthcare providers who engaged in anti-competitive mergers and developed remedies to address some of those problems. So that's just kind of a quick smattering of a few examples of matters where we've had to take action. Let me plow ahead here. Who enforces the antitrust laws? And so this one is really, it's quite a lot of folks. So, there's government enforcement from the Department of Justice Antitrust Division and the Federal Trade Commission. So yes, there are two federal agencies that enforce federal antitrust laws. They tend to have certain industries where they've developed expertise over many, many years. And so you tend to see, DOJ handling a certain type of case and the FTC handling another type of case. There's also virtually every state has, its own set of antitrust or, trade regulation laws. And so state attorneys general also enforce both federal and state antitrust laws. And then last but certainly not least, there are, private parties, private attorneys general, as some of the laws refer to them as. You can bring your own lawsuit under both federal and state antitrust laws. So there's quite a few parties that enforce the antitrust laws. And as I have a really brief, you can briefly see some of those cases can even be criminal. For example, the Department of Justice actually sends people to jail for engaging in criminal price fixing. And normally when that happens, someone goes to jail, and then my office can file a lawsuit civilly to try to get money back for consumers. So it is actually a federal crime to violate the federal antitrust laws. One thing that I know folks were interested in is, so what on earth is the difference between the federal and the state antitrust laws, and do we need both sets? And the answer, I think, is a resounding yes. So, for the most part, what's a violation under the federal antitrust laws, does does track a violation under the state laws. There are some exceptions because there is not always agreement necessarily, that this conduct may or may not be competitive or anti-competitive, and so maybe the federal antitrust laws don't reach it, but maybe we can reach it under the state antitrust laws. So there are some examples of that where they don't completely track, so that's one point. Another point is that depending on where, what type of plaintiff you are, if you are purchasing a widget from companies that engage in a price fixing conspiracy, you have a cause of action under federal. You can sue them under federal and state antitrust laws. If, on the other hand, you did something, you're more of an indirect purchaser. Say, for example, there's a piece of your television that was part of a big conspiracy, right? But you don't really purchase that part. You purchase the television when you go to Best Buy. But nonetheless, you have paid more for that because people were violating the antitrust laws and price fixing some of those components. Under the federal antitrust laws, you can't sue. That's what the Supreme Court has said. But under many state statutes, maybe you do have a cause of action. And so Washington has kind of a hybrid approach. The Attorney General's office can bring those cases on behalf of consumers, but so sometimes who actually can bring a lawsuit varies under federal or state. And then finally, just the different remedies available, what type of relief you can get. There's treble damages, 3 times the monetary relief for private parties under the federal antitrust laws, but under some state laws, it may be more limited. Sometimes you can get injunctive relief. Sometimes you can't. So those kind of details will vary from case to case. So now is probably a good time for me to pause to see if there are any other questions. Yep.
There are some questions, Jonathan. So this one I think was asked twice. How does antitrust law relate to Citizens United? And I think when they're talking about Citizens United, they're talking about the Citizens United case. And then a second part to that question is, are there ways to use antitrust law to protect democratic institutions? For instance, undue influence over our city council. Is undue influence over our city council a violation of antitrust in any way?
Mm-hmm. So those are good questions. The short answer is that the antitrust laws are constrained by conduct that would be protected by the First Amendment. And so for example, if 2 competitors, head-to-head competitors decide that they're going to get together and kind of lobby their representative, and they do it in an anti-competitive way, the antitrust laws are not going to reach that. It's called the Noer-Pennington doctrine, which is more technical than I need to go through here. But essentially, petitioning government is protected, and the antitrust laws are probably not going to reach that. Which really sort of really focus on the conduct of commerce and sort of the terms of trade. So when it comes to like political donations, things that the Supreme Court has sort of viewed as being tied into First Amendment core political speech, the antitrust laws are probably not going to reach those.
We have 10, Elena just gave us a nice heads up, 10 minutes before our 5-minute wrap up.
Okay, we should probably jump into your section, Lynn.
Okay, all right. Great, thank you. Before I jump on it, I forgot that we normally do a disclaimer that views and opinions expressed today by us do not reflect any formal opinions by our office. So we We always have to do that and make sure we don't get in trouble with our office. So I wanted to say that before I begin our my piece of the presentation. Let me share my screen. Let's see here. I want to make sure I pull up the right. Great. Pull up the right presentation to show everybody. Okay. Let me, sorry, technical difficulties. Let me. Okay, got that here. Can folks see? Yeah, okay. Great, so now that you are all experts in the antitrust law, we can
look at presentation mode, Lynn?
I'm sorry?
Can you put it in presentation mode?
Oh, sorry.
You see it, yeah.
Let me get, oh, there we go.
There we go, thank you.
Awesome. So now that everyone's an expert on antitrust laws, we can see how they apply in the big tech or technology industry. I thought one good way to kind of segue into big tech is to look at the House Judiciary Antitrust Subcommittee investigation that was conducted in 2019. So the subcommittee actually began a pretty extensive investigation into 4 major tech companies, Facebook, Google, Amazon, and Apple. And I think it's fair to say that when you look at big tech and how it's described in the media or how it's covered in the press, they're more than likely covering, talk about one of these 4 companies. The purpose of the investigation was to document competition problems in digital markets and to determine whether the existing antitrust laws and framework actually adequately addresses any problems that were in these digital markets. And the investigation was pretty extensive. It lasted for 16 months. The committee interviewed many witnesses that included market participants, government regulators, scholars, and experts in the field of antitrust. They even subpoenaed and got the CEOs of these 4 big tech companies to testify, kind of putting them in the hot seat at a congressional hearing about competition on digital markets. And what the committee found, well, first off, they found a lot of things, and they published it in a 450-page report. And what they found was that together these companies form and they provide the infrastructure that enables exchange of information and communication and goods and services on the internet. While these companies have different businesses and they operate different business lines, there were some common themes and problems with these companies with regards to competition. One being that these companies first started off as these scrappy startups at the time that they began, and they challenging the status quo at the time, and they emerged to be these large monopolies with massive market power. And they abused their market power by charging high fees, imposing oppressive contract terms, extracting valuable data from businesses and individuals that rely on their platform. The House Committee also found that these companies act as gatekeepers, meaning that they control who can access the markets that they operate in, and that they have the ability to survey new businesses and identify potential competitive threats and eliminate competitors before they can encroach on their dominance in the markets that they operate in. No, I just went over that slide. So I was going to kind of go over, obviously, probably can't talk in too much detail about everything that was found in the House investigation. It was a 450-page report, but I thought I'd kind of give some overview and some highlights of what they found for each of the specific companies. So they found that Facebook obviously is a monopoly power or a monopoly in the social networking market through its family of products. Many of you probably know that Facebook doesn't just own Facebook itself, it owns Instagram and WhatsApp and Facebook Messenger. On average, there are about 2.47 billion daily users worldwide that use at least one of these 4 Facebook products. And more people actually spend time on these products, on these Facebook apps, than other social media platforms like Twitter or Snapchat. So the House Committee identified that there really isn't any competition to Facebook in terms of the social media or social networking market. And there were a number of reasons for that. One being that it's a high cost, switch cost for users. So users who have an account on Facebook invest a substantial amount of time building their online profile and identity on Facebook. Either uploading photos and curating photos and engaging with other users on Facebook. And Facebook isn't interoperable with other social networking platforms. And they also don't make it easy for you to port your data, meaning like you can kind of transfer everything that you have on Facebook to, say, another platform like Google+. So there really isn't a viable alternative to Facebook. And also, I think in order for a user to kind of switch and use a different platform, it will require all their connections, right? Their friends and family who they use Facebook to connect with to also use maybe a competing platform, and that's hard. So essentially, Facebook users are kind of locked in once they are on Facebook.
You're doing okay on questions, Lynn.
Oh, okay, thank you. And with regards, to how Facebook operates, it's a free service, but the way, obviously, that they, nothing comes for free, and the way that they make money off of or generate revenue is that they sell targeted advertising to advertisers based on the vast amount of data that they collect from its users, and that's also an advantage that kind of makes Facebook, a monopoly. No other competitor has the same level and amount of data that they have on their users. I mean, if you think about there's 2.47 billion daily users that use Facebook or Facebook products, that's quite a large amount of data. So wanted to talk about one particular case that our office is actually involved with that is targeting Facebook's monopoly, and that is a case that Washington State, along with a coalition of 47 other states led by the state of New York, filed in December of 2020, challenging Facebook's monopoly. The complaint that was filed alleges that Facebook engaged in a series of anti-competitive conduct, where by acquiring a series of competitors and nascent competitors. One notable acquisition is Instagram. So, and when Instagram was launched in 2010, Facebook immediately identified Instagram as a threat. Instagram, many of you know, is a video and photo sharing app, and Facebook tried to actually develop its own version of Instagram, but it wasn't successful. It didn't gain any traction. And so they switched strategies and they decided that it's probably better to just buy out the company and rather than develop its own product for video and photo sharing. And so at the time, when Facebook bought Instagram, it was valued at $500 million. Obviously, Facebook saw Instagram as such a threat that they actually purchased and acquired Instagram for about $1 billion. And at the time that it was acquired, it was still a relatively young company. It was only just 2 years old. Another notable acquisition was WhatsApp, and Facebook acquired WhatsApp in 2014. At the time, Facebook didn't just identify WhatsApp as the only mobile messaging competitor. There were other players on the market that had a mobile messaging product, but Facebook saw that WhatsApp was a leader. It had over 400 million users, at the time that Facebook had acquired it, and they bought WhatsApp for $19 billion. I have to apologize. I can't mute out my background noise, so some of you may hear my one of my two children crying in the background. The life of a mother, right?
I think we're coming up on a few minutes before wrap up.
Okay, all right.
Switch to Amazon, perhaps? We have.
Yeah, absolutely. I was going to go over Google, but we can definitely jump over to Amazon. So some of this information might be duplicate from Katie's presentation and also some of the comments that came up during the chat session. But with regards to Amazon, the House Committee did find that Amazon had a dominant online marketplace, and it controlled about 65 to 70% of all U.S. sales. And the number goes up if you look at kind of worldwide. As many of you know, Amazon is a marketplace. So it doesn't just sell its own retail goods; it sells other products offered by small and medium-sized businesses who we refer to as third-party sellers. So there are about 2.3 million small and medium-sized businesses that sell on Amazon worldwide. And for some of these small businesses, small and medium-sized businesses, it's their sole source of income. To explain and talk about the extent of Amazon's market power, it's probably best to kind of look at their interactions with how they treat third-party sellers. One is, you guys might be aware that there was an investigative reporting by the Wall Street Journal last year over how Amazon misuses third-party seller data that it collects. So by virtue of being a marketplace operator and also a retailer, Amazon collects a vast amount of information from its third-party sellers. It takes that information and in turn uses it to launch its a competing product under its own private label brand. And sometimes it offers that product at a lower price. And so, obviously affecting these third-party sellers who sell on the same product on their marketplace. No matter how, these third-party sellers feel like they've been mistreated by Amazon, they don't feel that there's another alternative marketplace that they can turn to. Amazon has came up with its Prime program, which many of you know offers like same-day, 2-day delivery, right, for if you have a Prime membership. And that's a really good way to kind of capture a set customer base. And so many of these third-party sellers don't have feel that they can't have the same access to the large amount of customers as they would on say a different marketplace. And so they are willing to accept the kind of mistreatment that they've been, or certain contract terms that they may not accept from any other business. Another kind of like anti-competitive practice that we've seen with Amazon, or that the House had identified, was predatory pricing. So one of the things that they talked about in the House report was Amazon had engaged in predatory pricing to drive out one of its competitors. I don't know if any of you have heard of the website or business diapers.com. I think they might have been in existence back in 2008. So they were a company that sold diapers and baby goods online. And at the time that they were still in business, Amazon identified this particular company as a direct threat to the diapers and baby goods market online. And so Amazon engaged in a campaign to undercut pricing and kind of drive out diapers.com. And so they did succeed. So in a process of engaging in predatory pricing, Amazon actually lost $200 million, but they successfully drove diapers.com out of business. And what they ended up doing was they purchased diapers.com. And once they did, they discontinued that website. And briefly, I was just going to talk about some, example of maybe an acceptance of unequal contract terms with third-party sellers.
Lynn, before you jump into that, Elena, do we have time? I know we're we're coming up pretty closely here. We'll
gonna
have to like plan a course around this.
Yeah, sorry, we need to wrap up, but if you want to just do a 1-minute summary of kind of what do you think in terms of hearing what folks were saying in our report out and just seeing, the experiencing as an attorney in the Attorney General's office, how Amazon operates. How would you summarize kind of where your office sits and yeah, I don't even know, advice?
Yeah, well, so yeah, let me offer a few thoughts. With, of course, the caveat that I'm speaking for myself and not for the Attorney General or the Attorney General's office. I don't mean to oversimplify it, but this is complicated. So obviously we're part of several lawsuits now against Amazon, against Facebook and Google. So you're definitely seeing antitrust enforcers trying to flex some muscle against big tech. One of the big challenges, of course, is, and we didn't get into this in detail, but these cases are very, very, very fact-based. And so, the Googles and the Facebooks and if Amazon, if they were to be a defendant, they would get to say, well, here are all, the wonderful pro-competitive things, that we have done. And that's going to kind of go into one big pot, to stir and mix. And then a court is going to decide, which outweighs the other. Do anti-competitive harms outweigh the pro-competitive benefits? And, it's just very, very factual. And so, I think that the jury is out, figuratively and literally, on, whether the antitrust laws, are going to go further enough, to correct some of these issues. And so it's challenging, but it is very cutting edge. I did see a lot of questions in the chat that touched upon like antitrust and sort of labor laws as well. Do I have time to maybe say a couple quick things about that? Or okay, well, I'll say the answer is a lot of that is immune from the antitrust laws. Traditional organizing is immune. So unions, yes, they are exempt from the antitrust laws. I can say more. I can answer questions if folks want to touch base afterwards.
Thank you. Boy, lack of closure abounds with this one. I'm so sorry, Lynn and Jonathan, that we had to cut you off. Thank you so much for being here. And Katie, I'll turn it over to you to talk about next steps.
Okay. Yeah, thank you so much, Jonathan and Lynn. That was fascinating, and I wish we had 2 more hours to go through it all. Thank you also to our breakout facilitators and for everyone for being here and asking great questions. So we're probably going to be organizing at least 1 more workshop, perhaps more than 1. And to kind of keep this conversation going, we're hoping actually that Representative Pramila Jayapal will be able to be our guest at the next one, so we can dig in a little bit more to what's going on at the federal level on antitrust. But we are also very open to ideas of topics to explore further. So as we close here, we'll just keep this meeting open for probably another 4 or 5 minutes. And please put in the chat if there are burning questions you have that have not been answered tonight, topics that you would like to see addressed at future workshops, anything else that you just have to say before we go. Yeah, this is awesome. Thank you everyone for being here.